Thank you all very much for coming. I'd like to welcome everyone to this important and timely event on country of origin information research for persons with disabilities in the context of asylum law. And our speakers are going to talk about the ARC Foundation and Asylos Disability Project and how it fits into UK asylum law. My name's David Neale. I am the legal researcher at Garden Court Chambers. From 2014 to 2017, I was a practising barrister specialising in immigration and asylum, and I'm a co-general editor of McDonald's Immigration Law and Practice and the trustee of ARC Foundation. And with Jennifer Blair, who's with us this evening, I co-wrote a report called Bridging a Protection Gap, Disability and the Refugee Convention. I've worked in immigration and asylum law in quite a few different capacities, and in recent years I've been heavily involved with the Breaking the Chains project at Islington Law Centre, which works to improve legal outcomes for current and former unaccompanied asylum-seeking children from Albania, many of whom have disabilities and many of whom have been treated appallingly by the Home Office and many of whom have suffered from inadequate legal representation in the past. I also have a disability myself, namely autism. So I'd like to introduce our speakers for this evening. Maya Pritchard is the Youth Casework and Policy Manager at South London Refugee Association, and she's a consultant researcher with Asylos who's worked on the Disability Project. And Joe Pettit is an experienced researcher in the asylum and refugee sector and a consultant researcher with ARC Foundation who has also worked on the Disability Project. And Jennifer Blair is Senior Legal Protection Advisor at the Helen Bamber Foundation and an Immigration and Asylum Barrister at No. 5 Chambers. She has particular expertise in disability and asylum law and co-authored Bridging a Protection Gap with me. And in my years of working in immigration and asylum law, it's become increasingly clear to me that an understanding of disability should be fundamental to every asylum lawyer's toolkit. Disproportionate numbers of people seeking asylum have got mental health conditions such as post-traumatic stress disorder and depression. We also see clients with physical disabilities, developmental disabilities, and other types of disabilities. And these disabilities are often highly relevant to a person's asylum claim. Sometimes their disability is itself a reason they would be persecuted on return. Sometimes it increases the risk of being persecuted for other reasons, for instance, because it affects their behaviour or causes characteristics to be wrongly imputed to them by others. Sometimes it might make them more vulnerable to abuses such as human trafficking, for instance, by affecting their susceptibility to exploitation or reducing their ability to support themselves economically. This is something we often, that's often very significant in the Albanian cases that I'm involved in. Sometimes a person's disability affects their ability to avail themselves of state protection or affects how the state would treat them. Sometimes it affects their ability to relocate internally and rebuild their life, bearing in mind that the reasonableness assessment takes into account a person's individual characteristics and the situation they'd be in the place of relocation. And in many cases, disability also affects a person's engagement with and experience of the asylum process in the UK. The asylum process is often very re-traumatizing, very traumatic, and very disability unfriendly. And Jennifer's going to talk more about these issues when she comes to address the relationship between disability and asylum law. And I would say that understanding of disability in the asylum system is still extremely poor. Many lawyers and judges and Home Office officials have an outdated and limited understanding of disability, and often potential asylum claims based on disability are not appreciated or adequately advanced. Sometimes asylum claims based on disability are wrongly treated as so-called Article 3 medical cases, cases under the European Court of Human Rights judgment in Portrayal in Belgium. And this is a misconception because these are two different types of claim. A proportionally claim arises when somebody's health will rapidly decline, resulting in early death or severe suffering because of lack of appropriate medical treatment on return. But that's completely different from an asylum case based on disability, where someone claims that they will be subjected to persecution on return because of their disability or because of reasons that are related to their disability. The latter is not an Article 3 medical case. It's not about lack of medical treatment per se. It's about how people would treat you on return. Of course, the two types of claim may well arise in the same person's case, and they often do, but they shouldn't be confused with each other. And it's very important because having recognition as a refugee and refugee leave is much more advantageous for a person than just having discretionary leave under Article 3. So lawyers need to remember to consider refugee grounds first and foremost before they move on to Article 3 and other possible bases of stay. They need to recognise that a disability can be a basis for an asylum claim, not just an Article 3 claim. And with this in mind, country of origin information has got a vital role to play. Decision makers and lawyers need detailed, accurate, up-to-date information about how people with particular disabilities are going to be perceived and treated in a particular country. Now, this shouldn't be limited, as it so often is, to a laundry list of medical facilities or what medications are available or blandly generic statements about social attitudes to disabled people. It needs to be detailed and specific. And this might cover a range of different issues, depending on the country and the person and the nature of the disability. It might cover abuse in medical facilities or forced institutionalization. It might cover abuse by the police. It might cover abuse by family members, abuse by faith healers. It might cover being accused of witchcraft or demonic possession. It might cover the prospects of homelessness and destitution and consequent violence and exploitation or vulnerability to trafficking. There's a whole range of issues on which country of origin information that is detailed and specific is needed. Country of origin information research can make the difference between winning and losing a case, and a good report can be literally life-saving. It's important to remember that in this field we're dealing with people's lives, and that applies to lawyers. It also applies to COI researchers, where your research is used in the asylum decision-making process. Another major issue, which isn't the main focus of tonight's session, so I'm going to mention it only briefly, is the poor level of understanding among lawyers and judges about the effects of trauma on memory, and the fact that decision makers often still reject people's accounts on the basis of inconsistencies, when in fact that we know that the truthful accounts of traumatized people are often inconsistent. That's not something that we're going to focus on tonight because it's less of a COI issue, but it's something we get into in bridging a protection gap. So if you're a lawyer in this area and you're interested in this issue, that's where to look. My headline point here is everyone working in the asylum system needs to put disability issues at the centre of their work, and that includes lawyers, judges, officials, and country of origin information researchers. And in many cases, lives depend on it. It's critical that we as a profession or as a group of professions get better at disability issues. And I say this both as someone with a lot of immigration law experience and as a disabled person myself. So without further ado, I'm going to hand over to our speakers to talk about first of all, Maya and Joe will talk about the disability project carried out by ARC Foundation and Asylos, and then Jennifer will talk about the legal context and how disability is relevant to an international protection claim. So thank you very much for coming, and I'll hand over to our speakers.
Thank you, David. I will begin with a bit of background behind how this project started, and the fact that when we started this work, it became really very clear to us that understandings and responses to disability vary widely and are very much context dependent. We found that in the field of international protection, the approach to disability tends to reflect the policy and decision-making practices within host states, but as well as the understandings and unconscious biases of decision makers, legal representatives, and country of origin researchers like ourselves. And so the lack of good quality country of origin information on issues related to disability is at least partly related to the way international protection claims for persons with disabilities are often presented. So as David said, with a narrow focus on medical responses to an impairment. However, the lack of relevant source material is itself linked to the limited visibility of persons with disabilities within societies globally. These were issues that were being repeatedly raised with us at Asylos and ARC Foundation prior to the project. So, for example, lawyers representing Nigerians with dependent children with disabilities and unaccompanied children with disabilities seeking asylum, identified a critical information gap in COI used and produced by the Home Office. A subsequent rapid review of COI reports produced by a colleague on Nigeria found that limited information relating to persons with disabilities, and specifically to children and young people with disabilities. As I'm sure you'll be aware, the significant information gap risks the refusal of cases involving persons with disabilities because of a lack of objective and relevant evidence that might support their protection claim. So in response to these issues that were being raised by legal reps, and thanks to some funding from Paul Hamlin, we developed a joint project to address information gaps about persons with disabilities who are seeking international protection, focusing initially on children and young people with disabilities in Nigeria as a case study. The project overall has included an unpublished rapid review of COI relating to persons with disabilities to assess the level and form of inclusion of persons with disabilities within selected COI sources on Nigeria. And even though it's unpublished, I will go through some of the findings with you today. Secondly, a country report on the situation of children and young people with disabilities in Nigeria. And this combined interviews with individuals with authoritative knowledge on the topic, including or primarily with experts with lived experience of disability, alongside other experts from country information available in the public domain. And then finally, a principles document, a handbook and a training module to guide those conducting COI information research on disability-related issues. So as I said, I'm going to briefly present the main findings of the unpublished rapid review of COI sources we undertook. I should note that the review was rapid due to time constraints and did point to a need for a more systematic review. I will then touch on the Nigeria country report, which is available on both of our websites, and my colleague will put into the chat now. So the rapid review of COI sources, this involved 16 reports that were published since 2018, which we chose for the review. And these were from a range of government and non-government COI producers. This included the Home Office, the US Department of State, the Australian Department of Foreign Affairs and Trade, the European Asylum Support Office, and ARC Foundation itself. The COI content of each report was reviewed in relation to use of terminology, topics raised, including context and the positioning of content within the report, use of disability-specific sources, and references to intersectionality. Findings from the review were analysed in relation to 4 key issues. That was visibility and portrayal of persons with disabilities, topics included or omitted, intersectionality, and sources relied upon. Above all, the review revealed a wide variation in approach to the inclusion of persons with disabilities in COI reports between institutions, which may contribute to inconsistent decision-making in international protection claims involving persons with disabilities. It also revealed an overall lack of visibility of persons with disabilities in reports, an omission of key topics and insufficient information on others, no reference to intersectionality, and a lack of transparency of sources. And I'll just go through the key findings, if you allow me to change the slide. So yeah, these were our key findings. And firstly, in terms of visibility and portrayal of persons with disabilities, we found that the visibility and portrayal of persons with disabilities is inconsistent, undeveloped, and limited. We found that persons with disabilities are mainly represented in relation to mental health and witchcraft. Disability is not consistently referred to in the terms of reference, and some reports contain no information whatsoever on persons with disabilities. Regarding topics included and omitted, topics included included discrimination, abuse and exploitation, legislation, prison conditions, healthcare, education and employment. Topics that were either omitted or included with very limited or insufficient detail included implementation of legislation and policy, information specific to persons with physical, intellectual or invisible disabilities, or children and young people with disabilities, and the economic situation of persons with disabilities. When it came to intersectionality, none of the reports contained any explicit references to the intersection of disability with other individual characteristics, although some reports did include information on age and disability, and then related to a range of different issues. Other reports included limited information on internally displaced persons and mental health, HIV status and employment, and women with mental health issues. As far as sources were concerned, there was a real lack of balance, breadth, specificity, and transparency within sources. There was only one explicit reference to the term persons with disabilities in a bibliography, and that was across all of the reports. And there was little to suggest that oral information was sought directly from persons with disabilities, including disabled persons organisations. So our work on this review helped us to understand how the information gaps better and informed our approach to the country report on Nigeria. As mentioned, this report is both a case study to demonstrate what COI for persons with disabilities could look like, and a potential COI source for future cases involving children and young people with disabilities from Nigeria. So I'll go quickly through some of our main findings now from that research. The report is divided into 9 core sections. Each spotlights pressing issues relevant to protection claims from children and young people with disabilities, and include risks from both non-state and state actors alike. Topics that we included were organised under these headings: societal discrimination, exploitation and other types of harm, legal and policy frameworks in the implementation and data collection, state perpetrated discrimination and state protection, access to services and support, including health, education and child protection, institutionalisation and treatment of returnees. And so our findings covered over 200 pages and painted a really troubling picture of the situation of children and young people with disabilities in Nigeria, despite the recent adoption of legislation by the state to bring them in line with their obligations under the Convention of the Right of Persons with Disabilities. Sources highlight the multiple forms and layers of discrimination by state actors and within communities and families, and the lack of protection or access to address that affect children and young people with disabilities in Nigeria, severely impairing their lives and in many cases putting them at risk of further or exploitation itself and harm. A summary of our findings and the full report can be found online, and as I said, my colleague was going to put the link in the chat. So the report draws extensively on insights and information from interviews and correspondence with 8 experts from Nigeria, most of whom have lived experience of disability themselves. This is particularly important as our initial desk research, we encountered severe limitations that mirrored many of the challenges and limitations noted in the COI review above. So these challenges and limitations included a lack of visibility of persons with disabilities in publicly available COI sources, limited disability-specific sources or general sources with disability-specific information, resulting in an over-reliance on a few sources, a lack of information specific to children and young people or persons with disabilities or specific to type of impairment, and a lack of sources taking account of different aspects of the identity of persons with disabilities. And so, yeah, a lack of sources taking an intersectional approach. Interviews with disability experts in Nigeria allowed us to go beyond these limitations and fill in really important information gaps. Thanks. So I'll now hand over to Jo, who's going to speak more about approaches to disability itself.
Thanks, Maya. So one of the main learnings actually from the COI review and our research on Nigeria is a recognition of the need to understand disability much better. And, we became aware very quickly that the subject becomes complex because, in fact, understandings of disability vary significantly depending on the context. And this can lead to very different responses and very different outcomes. And this is certainly true for the international protection context. So we felt it important to focus briefly now on what is disability and on the main models of disability before going on to consider international protection for persons with disabilities. I'll also briefly introduce our principles for conducting COI research on disability, which are available in full online also on the Asylos website. We should say from the outset that Amaya and I are not ourselves disability experts, though we have learned a great deal through working on this project. And we were helped significantly throughout by our colleague Sarah Green, and also a steering committee which includes persons with lived experience of disability. And in fact, Jennifer was a member of that committee too. So yeah, in terms of what is disability, a common view is that it's a condition that's inherent in the person, or a medical condition. For example, you might think of something such as spina bifida or autism spectrum disorder, or you might think of an impairment such as blindness. However, more contemporary understanding of disability, and one that's actually reflected in the Convention on the Rights of Persons with Disabilities, is that disability is the interaction between an individual's personal condition, such as being in a wheelchair or having a visual impairment, and environmental factors, such as negative attitudes or inaccessible buildings, which together lead to disability and affect an individual's participation in society. Persons with disabilities are not a homogenous group. They, of course, experience impairment and disability differently, and multiple aspects of their individual identity and specific contexts will shape their life experiences. So in addition to the form of impairment, including those that might be invisible or hypervisible, both personal and environmental factors can interact to exacerbate disability or to alleviate it. These combined factors determine the extent to which an individual can participate in society, and as a result, the extent to which disability exists for them. So responses to disability are based on conscious, as we've mentioned already, or often unconscious understandings. Those with similar views are commonly considered to adhere to a specific model of disability. Models of disability themselves are not value neutral, and they have significantly different implications and frequently a political dimension. They can differ geographically, culturally, historically. Each provides often strikingly different explanations for disability that can dictate responses at an individual, family, community, national or international level. So the dominant models currently are said to be individual deficit models, social construct models, and human rights models. Respectively, they focus on the impaired individual, or how a society responds to impairment, and on persons with disabilities as rights holders. So individual deficit models represent individual impairments as an abnormality, usually with a medical or a moral cause. Disability as a biomedical problem remains a very widely held approach, with interventions focused on diagnosis, on treatment, rehabilitation, and also on prevention. But also widespread are models of disability that attribute the cause of individual impairment to some kind of a moral lapse or sin, or possibly witchcraft or sorcery that might be thought to have been committed by the person or a family member. Both moral and medical models, what they have in common is that they hone in on individual impairment as a human aberration, and for this reason they're often referred to as individual deficit models. In contrast, social construct and human rights models shift the focus away from individual deficits. They propose that it's primarily the social and environmental barriers and oppression rather than individual deficits that disable people with impairments. The focus in these approaches is therefore on achieving changes in society rather than individual adjustment and rehabilitation. A strong social construct model approach is common within the UK. In this approach, disability is understood as a socially created problem where social and environmental barriers exclude persons with impairments from participating in society. And notably, disability is viewed as clearly distinguished from individual impairment. In the international protection context, it's particularly important to be aware of human rights models, which represent persons with disabilities as equal holders of human rights. This understanding of disability is relatively recent. This approach shares common ground with social construct models, but responds to the critique that these models do not necessarily take sufficient account of the realities of living with an impairment, and also of the intersectionality of disability with other identities, including minority and cultural identification. The human rights model of disability has been used effectively to advocate that persons with disabilities should be valued as equals with all others, entitled to enjoy human rights granted to all. According to the Convention on the Rights of Persons with Disabilities, a rights-based approach to disability is not driven by compassion, but by dignity and freedom. It seeks ways to respect, support, and celebrate human diversity by creating the conditions that allow meaningful participation by a wide range of persons, including persons with disabilities. Instead of focusing on persons with disabilities as passive objects of charitable acts, it seeks to assist people to help themselves so that they can participate in society, in education, at the workplace, in political and cultural life, and defend their rights to accessing justice. However, as we've mentioned, asylum decision makers and country of origin information on persons with disabilities frequently in practice look more closely at the issue of availability of medical treatment rather than other potential forms of exclusion or disadvantage within society. And this is the case despite the ratification by most host countries, including the UK, of the CRPD. If actors within the asylum process view disability through this medical lens, the cumulative impact of often multiple and interlinking disadvantage and exclusion faced by the person with disabilities in question, as David spoke about at the beginning, will be overlooked, and any decision will, as a consequence, be made on partial information only. So based on our learning from the research for the Nigeria report, and thanks to, again, invaluable input from Sarah Green and from the steering committee, we put together a set of principles for conducting COI research, country of origin information research on disability. And it's our hope that these principles will encourage country of origin information researchers, legal representatives and decision makers alike to take a more holistic and informed approach to international protection claims involving persons with disabilities, and that this in turn might lead to an improvement in the availability of good quality country of origin information research and also obviously then well-founded decisions. We'll focus on 3 of the principles here, but I would encourage you to have a look at the full set, which, as I mentioned, are available online. And I think Mayor's just put the link in the chat. So the first principle we'll talk about is a person, not a disability, perhaps the most fundamental one, and one that should guide all our work, is that persons with disabilities are first and foremost persons, and as we've seen, equal holders of human rights and entitlements to fundamental freedoms. It's also important to remember that persons with disabilities may or may not self-identify in terms of any impairment or disability. Equally, they may or may not wish to identify themselves or be described as vulnerable or as a victim, since this language may be viewed as disempowering and takes little account of their agency. However, in the context of international protection claim, it may well be necessary to focus on the vulnerability of an individual or a group. And according to the legal norms and procedures, a person with disabilities may be described as a victim of discrimination or persecution, for example, or at risk of becoming a victim if they were returned to their country of origin. So a second principle, persons with disabilities are not a homogenous group, adopting an intersectional approach. As we've said, the experience of every person with disabilities is unique and dynamic. And we'll hear in a moment, decision-making in international protection claims for persons with disabilities demands that we look at how an individual's impairment combines and interacts with other identities and potential sources of social disadvantage and discrimination to shape their experiences and the risks that they face. And this is an intersectional approach. Intersectionality is a term that's mentioned a lot, not always understood. It's basically an analytical framework that helps us to understand how a person's social and political identities combine to create different forms of discrimination and privilege. Multiple factors of advantage and disadvantage may arise from these identities, and they can intersect in both empowering and oppressive ways. For our purpose, an intersectional approach helps us to reach a more nuanced understanding of how multiple factors can shape risks, needs, and experiences of individuals who are seeking international protection. This can be complicated, and it can give rise to a whole set of additional considerations when you're developing a research strategy. For example, if we're researching the situation of children with disabilities, we also need to be alert to more general child-specific rights and rights violations. Intersectional discrimination refers to discrimination that people experience arising from different aspects of their identity that, when they interact, result in a level of prejudice or persecution that's higher than if a single aspect of their identity is considered in isolation. Whereas when the forms of discrimination that arise from several aspects of a person's identity are considered in isolation, this is known as additive discrimination. Both are forms of multiple discrimination. So relevant aspects of a person's identity that country of origin information researchers might want to consider include this long list that you'll see on the slide, and potentially many other. But so things such as age and life cycle status, stage, employment status, ethnic origin, evidence of personal resilience, form of impairment, gender identity or expression, and so on. Each of the person's identities may interact with each other. And so what we need to try and understand is how, taken together, they might increase risk of harm or influence the type of discriminatory and or persecutory conduct inflicted against the individual, and how they might exacerbate the effect of the harm on the individual. So the third principle that we're going to talk about here is nothing about us without us, so including the voices of people with lived experience. What does this mean in this context? Persons with disabilities have insights into their experiences that are not available to persons without disabilities self-evidently. However, their voices are, in practice, often silenced or ignored, depriving legal representatives, people conducting country of origin information research, and decision makers of a credible source of knowledge and information that's informed by lived experience. This is linked to the fact that despite the obvious capabilities and agency and highly effective activism of many persons with disabilities in diverse contexts, persons with disabilities often have a limited visibility and voice within societies globally. This may be due to public perceptions of disability involving stigma and shame, which result in deliberate exclusion or different forms of institutionalized discrimination, and or the lack of family, community or state support that would enable full participation of persons with disabilities within society. So the lack of visibility and voice of persons with disabilities, while of course not universal in any context, is also reflected throughout the international protection framework. Actors within the international protection process, including legal representatives, country of origin information researchers such as ourselves, and decision makers, may have a limited understanding of or exposure to the experiences of persons with disabilities. This is then compounded by limited or inaccurate reporting of disability-related issues in local, national, and international media and other sources. So in the face of this, country of origin information researchers will need to search widely for disability-specific information in published sources. However, they might need to move beyond this and seek to fill information gaps, as we did for the Nigeria report, through direct correspondence or interviews with people with lived experience and disability experts from within the country concerned. Okay, so I'm going to hand you on now to Jennifer, who's going to talk about the legal context, international protection for persons with disabilities.
Thank you very much, Jo, and thank you to David and Garden Court for having me here today. If people have any questions at any point during the talk, we do have the Q&A function at the bottom and we'll come to it at the end. So please do put questions in the chat. We've saved some time to have a bit of a discussion at the end. Also, if my dogs whiff, apologies, I will sit on them pronto. So to start off with, I just wanted to highlight that even though persons with disabilities may be granted asylum under the Refugee Convention or granted subsidiary protection, their claims for international protection are often inappropriately framed. Mainly, this is when disability is viewed through a medical lens with a focus on availability of healthcare on return, as opposed to a focus on risk profile, which would involve a holistic assessment of the type of treatment the individual may face as a result of their disability and other aspects of their background, their identity, their status. David's already touched on this in his introduction, and it's a situation where lawyers or judges may mistakenly conflate asylum claims based on disability with Article 3 medical claims when the two are different things. Therefore, it's crucial that legal representatives can frame a case and researchers frame their research questions in such a way to take that more holistic view. The Helen Bamber Foundation report might be a useful source for looking at ways of doing this. I will just put the link in the chat now. So today, what I'm going to present will be a summary of some of the relevant guidance contained in that report and other sources with advice, suggestions and observations on what it means for those conducting country of information report, drawing from the approach taken in the Asylos and ARC report that you've already got a link to. And for today, I'm going to focus on disability-specific considerations under the Refugee Convention. So protection under the Refugee Convention. It's a principle under refugee law that the decision makers must take into account the subjective risk and therefore the individual profile and characteristics of the applicant when assessing their protection claim. What I'll go through now is the relevance of disability in this and the impact this should have on our analysis of key legal tests. So firstly is the principle that disability can increase the risk of persecution or can itself be a reason for persecution. The individual concerned may be said to form a particular social group. For a claim to fall within the Refugee Convention, the fear of persecution must be for one of the 5 convention reasons, which you can see here: race, religion, nationality, political opinion, or membership of a particular social group. Disability can be relevant to this analysis in a number of ways. For example, a person's protection claim may be based on a fear of persecution because of a particular convention reason, such as their religion, but their disability may put them at greater risk of being targeted than another person with that same characteristic. So, for example, if their disability meant they would be perceived as acting atypically or identified as particularly vulnerable, this may increase their risk profile. However, sometimes disability may itself form a particular social group, which the UNHCR defines as a group of persons who share a common characteristic other than their risk of being persecuted, who are perceived as a group by society. The characteristic will often be one which is innate, unchangeable, or which is otherwise fundamental to identity, conscience, or the exercise of one's human rights. Whilst it may seem obvious that disability could fall within the scope of this definition, this hasn't always been clearly recognised in refugee law. In this regard, a very important recent case is DH. The citation is 2020 UK UT 223. I will put a link to it in the chat. Also on the Upper Tribunal's website, which held that a person living with disability or mental ill health may qualify as a member of a particular social group. This case is also important because of how it interprets the definition of particular social group. Now, if you're not a lawyer, this is a brief dip into some technical law for you. In the EU Qualification Directive and in the UK's regulations that implement it, 2 criteria for when a group will form a particular social group are set out. One is that members of that group share an innate characteristic or a common background that cannot be changed, or share a characteristic or belief that is so fundamental to identity or conscience that a person should not be forced to renounce it. The other criteria is that people have a distinct identity in the relevant country because it is perceived as being different by the surrounding society. Before DH, some tribunal cases had held that both of these requirements needed to be satisfied, not just one. DH held that that was wrong and that the requirements were alternative, not cumulative, that is, only one needed to be satisfied. This was very helpful for disabled people's cases because having a particular disability will usually amount to an innate characteristic, one that people can't change themselves, or a common background that cannot be changed. And on the interpretation in DH, they do not need to show as well that people with that disability have a distinct identity in the relevant country. The HBF report explains what the tribunal found, and the quote is on the slide. I won't read it out in full, but we can see that it mirrors the UNHCR definition. Unfortunately, at the moment, the government is intending to reverse this aspect of DH through clause 32.2 of the Nationality and Borders Bill, which will require, once again, that both of those factors are in place, not just one. So we'll require that the innate characteristic and distinct identity criteria are both met. This change will be harmful to disabled people's asylum cases, more of whom will miss out on refugee status as a result, unless they can draw on specific country information showing that people with their type of profile, or disabled people more generally, have a distinct identity in how they are treated in the relevant society. So it will put a bigger evidential burden on their cases. It should be noted, though, that under existing law, people who are found to be at risk of persecution but who are not found to be refugees solely because of them not falling into one of the convention reasons should still receive humanitarian protection. So that's not being changed by the Nationality and Borders Bill, and it is in most respects similar to refugee status, although not in all. So what does this mean for country of information research? This point means that research questions will need to adequately address how persons with disabilities are viewed, portrayed and treated by surrounding society in the country of origin. This include looking at the role of religion, social and cultural attitudes in influencing the perception of persons with disabilities, as well as how disability is defined in the relevant country. This kind of information will help evidence whether or not persons with disabilities are perceived as being different from the rest of society and mistreated and discriminated against on this basis. Persons with disabilities may experience discriminatory treatment that gives rise to a well-founded fear of persecution. This may be on the grounds of disability or because of another convention reason, but either way, it's important to remember that persecution can involve a single serious act of harm or a set of circumstances which cumulatively amount to persecution. This means that sufficiently severe discrimination can amount to persecution. The Home Office, you might sometimes see in refusal decisions, they'll say this isn't persecution, this is only discrimination, but discrimination can cross the threshold into persecution. For example, the UNHCR has stated that discrimination can amount to persecution where it leads to consequences of a substantially prejudicial nature, such as serious restrictions on a person's right to earn their livelihood, to practice their religion, or on their access to normally available educational facilities, which can be really important in, for example, disabled children's cases. The Helen Bamber report provides some examples of disability-specific discrimination, which cumulatively or taken alone could constitute persecution. These examples are set out on the slide, but what you can sometimes find in cases where you're looking at what the circumstances would be for a disabled person on return might be there'd be a number of different factors which taken together mean the person's standard of living, because of the fear of discrimination or the discrimination they're facing overall, is so catastrophic that it would meet the definition of persecution. In addition to being a reason for persecution in its own right, disability may also enhance the risks a person faces for other reasons, such as religion, political opinion, or gender. The HF report offers examples of the ways in which disability may interact with other aspects of a person's identity, making them more vulnerable to persecution, including, and again, these are on the slide, but for example, I've worked on cases where it would be returning someone who suffers from delusions that they have magical or religious powers, sometimes described as magical thinking, to a country where blasphemy is punished very severely. Sometimes it has the death penalty or long prison sentences without due process. So somebody who's behaving, who might be treated as blaspheming when they're talking about what they think they could do, would be at risk of persecution. And it would be a disability-related reason. A disabled woman displaying disinhibited behaviour in certain countries could cause her to experience persecution from the state or with complicity of the state, and the other examples here. So what does this mean for country of information research? An understanding that for persons with disabilities in particular, persecution may be established through an accumulation of violations. It sometimes requires rewiring your brain in protection claims. You're not just looking for a single incident of torture or arrest or execution. It's a much wider picture than that in these kinds of cases. This means that researchers will need to have a good understanding and knowledge of disability-specific rights and their violations. This will require some familiarity with the United Nations Convention on the Rights of Persons with Disabilities and the obligations it places on signatory states. And in many cases, the states that you're looking into will have signed up to that convention. And there may be recommendations that the committee to that convention have made to the specific state that you can look into. Likewise, when evidencing multiple and cumulative forms of discrimination, we will need to be alert to other aspects of a person's identity that will inform their experience. This means taking an intersectional approach when formulating research questions, as discussed elsewhere in the seminar. I just wanted to give an example again from practice. I worked on a Jamaican human rights case, and often these disability protection cases might start off seeming like an Article 8 private life case about the obstacles someone would experience to going back. But then when you've got the country of information, you've done their research, or in this case, had a country expert report, it became clear it was a Article 3 serious harm or protection claim. And it was an expert report where it was this individual country expert who was commissioned to write a report. And there was quite a lot of toing and froing where they'd say, oh, well, there's this kind of disability benefit. And we'd say, but how do you apply for it? And she said, well, you need to have a fixed address. And we're like, okay, how do you get a fixed address to apply for your disability benefit? And having to really go into a lot of granular detail to understand the accessibility problems that somebody would face and how it would intersect with the fact that she'd be like an illiterate woman, how also her physical disabilities, how all of that picture would fit together on return. So sufficiency of protection for persons with disabilities. Where the source of persecution is from non-state agents, a person will not qualify as a refugee if there is sufficient effective state protection in their home area to protect them from the risk of persecution. While sufficiency of protection does not mean perfect protection, UK case law states that a well-founded fear of persecution may be demonstrated in cases where an individual has additional protection needs that are unmet by the authorities. And I put on the slide the two of the key cases in this area, but there doesn't have to be perfect protection, meaning there is no crime in that country. The Home Office often refer to this Horvath case to say, well, yes, the police force isn't perfect, but there is one. But what there has to be is protection from the kind of crime the person fears. So if the kind of crime someone fears is maybe sexual abuse in care homes, and there is very clearly no sufficiency of protection in that kind of crime, people are undertaking that with impunity, then the Horvath standard is not met, even if there's an excellent police force for if you're mugged in the street. So yes, it's about looking at whether you would be able to access that protection, but the Refugee Convention also expressly protects those who are unwilling to avail themselves of state protection. And you would look at the realities of how accessible that would be. So what would for example, I worked with a lady who was deaf and had never been taught any sign language, so she couldn't really communicate with anybody. How would she report sexual violence to the police in a country where she was also she was a stateless young woman in Kuwait? In reality, there would be no way for her to access what might for a Kuwaiti citizen woman without her disabilities to receive that state protection. So both principles are relevant for persons with disabilities. They often face substantial barriers to seeking protection. To demonstrate sufficiency of protection, state protection would have to be accessible and inclusive of any reasonable adjustments the person would need. The Convention on the Rights of Persons with Disabilities also places states under an obligation to make accommodations or reasonable adjustments where it is reasonable to do so. So related to this, we often find that decision makers suggest the intense suffering of persons with disabilities is the result of a lack of government resources rather than of any intention or deliberate harm or complacency towards persons with disabilities. And what does this mean for country information research? Country of origin information may at times need to go behind apparently neutral language and address whether the state could or should be expected to be aware of the position of persons with disabilities within territory control. So neutral official language may mask discrimination. Things that seem apparently even-handed may not be. Whether there is an insufficiency of protection by the state or complicity by the state in the mistreatment and persecution of people with disabilities. This means our research will need to go beyond the existence of policies and legislation that seem nominally to provide protection and focus on the implementation of these protections as well as the barriers persons with disabilities may face when trying to access them. For example, we may want to look at how persons with disabilities can register complaints of discrimination, human rights violations or violence in order to assess how meaningful the complaints process is. This can include issues such as whether people with disabilities in that territory have trust in the authorities, where and how a complaint is made, accessibility of the place of registering complaints, the outcomes of complaints that have been made in the past, whether they were upheld or not, how long the process takes. And disability may be relevant to decisions on internal relocation as well. So to qualify for refugee protection, a person has to demonstrate a risk in their home area, that they are also unable to escape that persecution by relocating elsewhere in the country of origin. Often we say if the risk is from the state, the person may not have a realistic internal flight option because the state controls that territory as well. But if the risk is from a specific person, a private actor, and it's the state's not able to provide sufficient protection in their home area, the question will be whether there is safety in another part of the country. The question of whether the person seeking asylum has a well-founded fear of persecution in their home area will be assessed first, and then internal relocation would be considered. The possibility of internal relocation is set out in the UN Handbook, the EU Qualification Directive, and the UK's immigration rules. Paragraph 3390 of the immigration rules sets out the two limbs to the assessment of internal relocation, which are the safety test and the reasonableness test. Detailed guidance on this can be found in Asylos's basic country of information training handbook, but which we will send out a link to with the speaking notes. But in summary, the first test to satisfy when considering internal relocation is whether or not there is a safe area to which the claimant can return without a well-founded fear of persecution. The second test is whether or not the claimant can reasonably be expected to stay in that area and in the context of the country concerned lead a relatively normal life without facing undue hardship. If not, it would not be reasonable to expect the person to move there. So if I'm scared of like my neighbour and the police won't protect me in my home area, maybe my neighbour's not going to pursue me somewhere else, but if the rest of my country is a war zone or there would be no support for me and I'm a very disabled a person with very complex needs, then internal relocation might not be reasonable, even if the persecutory element in my home area isn't present. On the question of undue hardship, the HBF report sets out the case law on whether relocation will be reasonable or unduly harsh, and gives an example of an unreported recent upper tribunal determination which found a young Afghan, this was before the fall of Kabul, but found a young Afghan with learning difficulties was entitled to refugee status because he would be at risk in his conservative home area of religious persecution because he had no ability to censor himself. He was very disinhibited in behaviour and appeared incapable of self-moderation. So the risk would be that conservative elements in his society would regard him as behaving inappropriately and persecute him. And because of his vulnerability, internal relocation was deemed unreasonable in the Afghan context. So that's the kind of way that internal relocation would need to be explored in these kinds of cases. And we're once again asked to consider the ways that certain hardships may be exacerbated by disability or have a disproportionate impact upon persons with disabilities. So again, what does this mean for country of information research? Country information can be used to illustrate how realistic it would be for a person with disabilities to rebuild their life in a new part of their home country. If a person with disabilities is unable to access an assessment of their individual needs and adjustments required them to achieve a subjectively reasonable standard of living, then internal relocation might be considered to be unreasonable. And often in the cases that we see, it's creates safety, safeguarding, well-being risks that are quite stark when properly documented and explored. For example, if kinship care as opposed to professional care is the norm in a particular country, someone with care needs who does not have a suitable carer in a new location could not relocate there. And a kinship carer isn't just that they once had an uncle that they knew 4 years ago, which is what you sometimes see in refusal letters. A kinship carer would have to be someone who is suitable, proactively willing and competent to take on that role, given that you're looking at what would be a durable outcome for this person on return. The existence of disability-based discrimination across the home state would be a relevant consideration for an internal relocation assessment, including for applicants with dependents with disabilities. Aside from the availability of services to meet care needs, other factors such as employment opportunities for disabilities would also be relevant. So thank you very much. That's the outline of the sort of way that some of the principle we talked about fit into the legal context. And yes, please do stay and ask us some questions, but I'll hand back over to David.
Hello. So thank you very much to all of our speakers for this extremely helpful seminar. And just one thing to mention, Asylos and ARC have started to scope for their next thematic research report. And we'll be happy to take questions on this in the discussion. And the scoping exercise means that they want to hear from lawyers in the field about what areas are in need of more country of origin information research. And a link's going to be posted in the chat about this. that will people who are working in the immigration and asylum sector will be welcome to contribute to that. So we're now going to take questions. If you could post questions in the Q&A, I know it says post them in the chat on the slide, but if you could post them in the Q&A, and I will I will put the questions to our panelists and perhaps answer them myself in some cases. So the first question we've got this evening is I would be interested in the interview guides and questions used in conducting direct research with individuals. And I think this is a question for Maya and Joe.
Do you want me to take that?
Sure.
Yeah, so there's some very useful guidance actually you can find in the appendix of the Nigeria report, or in the ARC and Asylos COI training handbook, which goes into some detail actually about how to instruct, or how to look for appropriate interview subjects, and the kinds of questions or the considerations to bear in mind when you're framing questions, and then how to safely conduct interviews and, pay attention to kind of relevant ethical considerations and things like that. So yeah, good guidance there. And yeah, in terms of the interview questions, drafting interview questions, I mean, the things to bear in mind sort of in headline, obviously, as we sort of mentioned, focus on the gaps in the information that's identified through the desk research, whether that's due to underreporting or, a fast changing situation, or the very specific features of the case that you're working on. And, think very carefully about the questions that interviewees with experience on the ground might be able to reasonably answer, and ideally also provide evidence for as well. So, that would take into account their expertise, their exposure to the issues, and also lived experience. And then in sort of thinking about framing of questions, as with any other kind of research, really, you'd want to try and use open questions and not leading questions wherever possible, to allow the person to decide how they want to answer, so as not to introduce bias into their answer or limit the scope of their answer. Obviously, having said that, you may then want to follow up with specific questions or prompt questions to elicit a more specific answer if that's needed, or examples. And with the Nigeria research, I mean, we use the opportunity of interviewing experts to provide us with more nuanced information and more granular detail and more specific information where possible. And found that very helpful. So, for example, on the issue of institutionalization, there was actually quite a lot of public source information on some pretty egregious treatment of people in institutional settings, but nothing that was specific to children and young people with disabilities, nor was it clear that would it make a difference what particular type of impairment the individual had, or what other factors might affect the type of institution that someone might be held in, or the way that they might be treated. So sort of people with particular profiles, such as returnees to the country, or victims of trafficking, etc. So I don't know, Mary, if you want to add anything, or if there was anything else you wanted to know more about.
We've got another question which we've been asked is, does your project support a PhD? I'm from Nigeria, but running a master's in Germany. I'll be done in March 2022 and would like to do research in this field. So again, I think that's a question for Maya and Joe, really.
Thanks, Maureen. Unfortunately, we don't generally collaborate on PhD research, but we'd be very happy to.
I've often thought that the interaction of disability and asylum law would be a great project for a PhD.
Yeah,
because there's a number of different angles. I mean, one that I touched on in the introduction, but that obviously we haven't talked about much this evening, was the whole issue of how disabled people are actually treated in the asylum system, and particularly how the assessment of credibility kind of ignores the effects of trauma and says, well, your account must be fabricated because it's internally inconsistent, when in fact we know that the traumatic memories usually are inconsistent. And there's a whole range of different PhD topics I can imagine out of this, but I'm not an academic, so take that with a pinch of salt.
One of the members of our steering committee is also from Nigeria. He's an activist from Nigeria who is currently doing a PhD in the UK on disability in Nigeria. And so, Maureen, I'm sure that he would.
And certainly, if someone did produce a doctoral thesis on disabled people's lived experience in Nigeria, if that were then published, that would be very useful to asylum lawyers, certainly.
Yes.
Because as we have established, this is a pre-existing gap in the evidence. So we've had a question: did you address the issue of referral mechanism? I think that means the national referral mechanism for victims of trafficking in your research and study. I think the answer to that would probably be, first of all, it's important to understand that the NRM is a different process from the asylum process. For a lot of people who are victims of trafficking, the two processes run in parallel. So someone will be referred into the NRM and they'll have a reasonable grounds decision and a conclusive grounds decision. And that's backward looking, that's ascertaining whether the person is a victim of trafficking in the past. Whereas the asylum process, which runs in parallel, is forward looking, is about whether the person would be persecuted in future on return. And obviously the one is very relevant to the other. But the asylum decision maker and the first tier tribunal in an asylum appeal are not bound by the NRM's decision as to whether the person is a victim of trafficking. Or they'll take it into account, but they're not bound by it. So my understanding of this research is that it's primarily to be used in the asylum context for assessing the risks that a person would face on return.
Yeah, precisely. I mean, in other projects where we've been focusing on the experience of victims of trafficking, the question of whether or not individuals who have been recognised through the NRM process within the UK and whether or not they would receive support in their countries of origin has come up. And so that has been something that we've focused on in those COI projects, and often is an extremely difficult area of COI to explore. But unfortunately, within the context of this project, we didn't have sufficient time to go into to that intersection.
In one great, just on that one great example of an Asylos and ARC report that does do that is the fantastic report on Albanian trafficked boys and young men, which for those of us who do a lot of work with Albanians has been really transformative in helping to build a case that many teenage boys and young men are vulnerable to trafficking or re-trafficking on return. And disability again factors into that, because mental and physical disabilities are a strong risk factor for being trafficked in the context of Albanian society. Just to build on this a little bit more, I would say COI, although these COI projects are primarily aimed at the asylum process, they can also be useful sometimes in the NRM process, because sometimes, for example, in the NRM process, the Home Office will call into question someone's credibility. They'll say, we don't believe this would have happened in your country. And actually you can point to COI that establishes that things like that do happen in your country. So, I certainly wouldn't say that COI is not relevant within the NRM process. But it certainly is. But as I say, those two processes are distinct, but they usually run in parallel. And of course, disability and trafficking are interrelated issues. Some disabled people are victims of trafficking, and some victims of trafficking are disabled people. And disability can be very relevant to the risk of trafficking.
I mean, we did try to look at that intersection, if you like, in terms of looking for information within Nigeria of whether, if someone had been a victim of trafficking and returned to Nigeria, how would that affect a person with disabilities or a child or young person with disabilities, how would that affect their situation, their risk profile, etc. And in fact, and also whether a child or young person in Nigeria, would they be more at risk of trafficking? We actually really came up pretty blank on that. I mean, we really didn't find any information on that. And in fact, it wasn't an issue that any of our experts could particularly comment on, I think, or add to.
Not that this was because it isn't an issue. I think it was just an incredibly thorny issue. And so, it was very difficult to unpick and to find evidence on. Although many experts did say that having a disability would put someone at increased risk of being exploited and trafficked.
And again, certainly, I have less involvement in Nigerian cases, but in my experience of running Albanian cases, that's a very important factor, that somebody's mental and or physical disability is very, very relevant and often decisive in establishing in an asylum appeal that the person would be at risk of trafficking or re-trafficking on return. So,
it's often a reason they were targeted for trafficking in the first place, in our experience at the Helen Bamber Foundation.
So great question there, and we've actually, I think, covered it from several different angles. Anybody got any more questions?
I had a question for the other speakers, if I may. I was interested in the point about people not wanting to be seen as victims, but then having to be framed as victims in this asylum process, and how, if any of the other speakers have any advice or thoughts on how to promote dignity for survivors going through this process who want to move on with their lives, who don't want to be framed by the kind of worst possible outcomes, or sit or be because of
that's a really great question. That's a really, really great question, because I think actually, certainly in my experience of doing asylum law, there's often a sense that what you're doing is kind of the opposite of what a good therapist would do. You're playing up how vulnerable and helpless a person is and how they'll be completely unable to cope on return, when and trying to evidence as far as possible that how helpless and vulnerable they are and how they can't take care of themselves. And often that's not very therapeutic, and often that kind of almost re-victimizes the person. But what I would say on that is, in general, it's very, when someone still has the asylum process and the threat of a negative asylum decision and the threat of removal hanging over them, it's very difficult to heal from trauma in general. And I've seen that, huge numbers of psychologists and psychiatrists that we've worked with have said that it's incredible, until you have security and stability, in the form of leave to remain, it's incredibly difficult to heal. And I think often as a lawyer, unfortunately, one sometimes has to prioritize the needs of the person's case and winning the person's case over what's good for them in a more mental health or therapeutic sense, or but at the same time, I also think there's another angle to this which is really important, which is to preserve the agency and decision-making power of the client, because in the case of a capacitous client, and most disabled people are capacitous, they have the right to make the decisions about their case. They have the right to be in the driving seat. I think often lawyers take a very supercilious approach and don't adequately explain to the person what is going on in their case and what decisions are being made. And actually, as a lawyer, your client, whether they have disabilities or don't have disabilities, and actually, a very large proportion of asylum seekers do have disabilities, but the point is the client has agency. They should be in the driving seat. They should be making the decisions about their case. And even in the very, very rare case where someone is incapacitous, their wishes and feelings should still be at the center of the decision making in their case as far as that is possible. So I think those are the two angles on it. For me, the role that we have as lawyers is often not very therapeutic, and of course we then have to expose the person in some cases to the trauma of cross-examination and so on. But at the same time, while our role is sometimes not very therapeutic in that sense. We also have to keep in mind through everything that we do that the client has agency, that it's their case, that they're in the driving seat, and I think that's something that lawyers often lose sight of. Have you got anything to add to that from a COI perspective, Maya and Joe?
I suppose as kind of Joe touched on in the presentation, the COI, our terms of reference and our questions, and just the way that we would kind of approach it and present the information is a recognition that persons with disabilities are in no way inherently vulnerable or victims. And so what we're investigating is the way in which governments and societies make certain groups of people vulnerable and victimize certain groups of people, and to really focus on that. And that reflects the models of disability and the way in which persons with disabilities are disabled by societies and not because of a kind of inherent impairment.
Yeah, and I think we always have to keep in mind that we're fighting for the rights of disabled people within an ableist legal system, and sometimes we have to compromise with that system in order to get the outcome for the client, and sometimes that does mean portraying a person as vulnerable and centering kind of a narrative of vulnerability, even where that isn't the narrative that we would sort of choose politically or therapeutically, if you see what I mean. Because we have to work with the the pretty bad legal system that we've got, with the appallingly bad Home Office that we've got, and with the pretty bad judges that we've got, and work within that system to achieve the best outcomes that we can for our clients. And often that does mean centering a narrative of vulnerability. This person will be exploited. This person will not be able to take care of themselves. And we've seen in how Jennifer's outlined the different aspects of an asylum claim. We've seen how vital it is, for example, in the internal relocation analysis, sometimes to play up that a person won't be able to care for themselves or rebuild their life in a new area, that they're too vulnerable to do that. And that's often what you need to show to win the case. And sadly, I've had some cases, and this is an almost macabre way of looking at it, but I've had some cases where people who had been asylum seeking young people had been battling the Home Office for so long that their mental health had got worse and worse as a result of battling the Home Office. And then that was what led to them winning their case, because they were now too disabled to be able to, for example, in the old days with Afghan boys, if you were disabled enough, you might be able to show that you wouldn't be able to relocate to Kabul. And, the same with Albanian young people. Often that the trauma, the re-traumatization and depression arising out of the asylum process has actually then ended up paradoxically being what leads to the person winning their case. And it is an almost macabre way of looking at it, but sometimes that is actually how people win their cases. And it just shows how those of us who try to be mental health literate and psychologically literate lawyers, we are struggling against a legal system which is not designed with people's mental well-being in mind. Sorry, I've rambled on a bit there, but
David, there's a question in the chat.
Yep, let's see.
Rather than the Q&A.
Yes. So, in the context of asylum seekers, is there any avenue through which these persons need involvement in exploring an expanded range of choices to appreciate their need for self-determination as persons with disabilities? And can people who have long-term needs and chronic conditions fall under the group of disabled people? And looking at your source of information in Nigeria, including government agencies, did you by any chance include refugees and asylum seekers who may have chosen to define their own definition of persons living with disability? Well, there's a few different questions there, so I think we'll take them one at a time. So we'll take the easiest question first, which is the second question. Can people who have long-term needs and chronic conditions fall under the definition of disability? And the answer to that is yes. One thing that it's important, one important caveat that we have to have in that regard is that while there are various legal definitions of disability. There's a legal definition in the Equality Act, there's a definition in the Convention on the Rights of Persons with Disabilities, so there are various legal definitions. Asylum law does not itself have a legal definition of what constitutes a disability. And obviously, as we've seen from Jennifer's presentation, disability can enter in a range of ways into the asylum process and can form a particular social group in its own right. But it's possibly a red herring to get too bogged down in the technical definition of disability. But yes, absolutely, people with long-term health needs, whether mental or physical, and chronic conditions, whether mental or physical, can be and often are disabled, both under the legal definition and for the purposes of asylum law. I think what the first question is asking is there an avenue through which disabled asylum seekers can have an expanded range of opportunities to exercise self-determination and choice? And I think I'll pass this over to Jennifer in a second, but I just want to say on that, I think in terms of the asylum system can often be very disempowering. It often strips people of agency. It often deprives people of power and agency and severely limits their choices. And that and as I was saying earlier, I think we as lawyers are sometimes complicit in that process. We sometimes end up depriving the person of agency and not putting them in the driving seat of their case and the forensic decisions that we make about their case. So I think it's very important in that context as lawyers and also as NGOs working with asylum seekers and so on, to put that person in the driving seat, to give them the chance to exercise agency and to make decisions about their case and their life as far as the legal system allows. And to make sure that people are making their own decisions rather than professionals deciding what's best for them. So I think that's a very important point. And Jennifer, have you got anything to add on that one?
I think country information has quite an important role to play, actually. I think that, if you're a lawyer dealing with a civil claim because someone's neighbours knocked down their wall, you would say, bring me all the information and I will draft you some stuff and stick it into the courts. But for an asylum claim, someone says, oh, well, I'm this ethnic group, I'm at risk in this country. And you can't really say, well, bring me your ethnic group and your country. It really involves, and sometimes the person themselves will be excellently well prepared with a portfolio of beautifully indexed evidence. But quite often, the evidence is only going to be country information. And that's not something that they're going to effectively present themselves because they don't know how to obtain it in a relevant and reliable way, present it in a relevant and reliable way. So when somebody is explaining what they want their choice to be, what their experiences are, what their life history is, it really is the role of the lawyer to then go away and make that corroboration happen. Sometimes you can do that research yourself. Sometimes it might be already in existing publications from the UK Home Office or another jurisdiction. Sometimes you might have to commission an expert report. But very, very often, because I give frontline outreach advice in various different organisations, very often I see people who've been told to come back when they've got their evidence, but then it's something they're never going to be able to get themselves, given the complexity of the situation and jurisdiction and their personal profile, and that itself is a form of discrimination, I think, in some of these cases.
I think that's absolutely right. And when I was practicing at the bar, it was always my view that when you're doing an asylum case, your job as a barrister going into the hearing is to be really well informed about the country, and certainly better informed than the Home Office, and to really have your head around the country evidence and the risks to the client. I often, did my own COI research in addition to that the solicitor had done. And I think Jennifer's absolutely right that good sources of COI are incredibly important because it can often be very empowering to a client when their lawyer really understands their country and the risks they face, and understands that what they're saying about their country is true, rather than that they're just shouting into the void and being disbelieved. Because often you'll see, a person will make an asylum claim and they'll set out in their interview what they fear, and then the Home Office will go away and produce a refusal letter that would be, below the standard of the average GCSE essay, and will just, contain some garbled stuff that they've got off the internet and haven't understood, and will say, well, we think your country's fine because the Department of State says it has a police force. And you see completely ludicrous sort of half-hearted attempts at internet research by the Home Office and so on. So actually, when you as a lawyer actually put the work in and really get your head around the country, read the relevant country sources, put in extra country evidence, and then are able to, then discuss with that person the situation in their country and show that you understand that what they're saying is about their country is true and that you've got evidence to support it. That, I think, can be very empowering. It's not replacing their narrative, but building the evidence to support their narrative.
And I think it's also in some of the, obviously disability people have very, very different situations. But for some people who, whether they themselves, because of their health status or whatever, don't really understand exactly what's happened in the past or can't articulate or recount it, they might be come across as a very poor witness, or it may be because nobody told them what was going on. They weren't involved in making decisions about their own life, and they don't because of the way that disabled people are treated in their country or their background. So I think it's sometimes you need to just grasp the thorn and say, this person is a poor witness. So how do I build their case and make that clear up front? Because otherwise you have people who are refused again and again and again because they can't articulate their claim properly, but they're never going to be able to. They need that support. Yeah.
So I think the headline point is that both of the professions that we're speaking about this evening, lawyers and COI researchers, have a huge role to play in this. Lawyers have to, as far as possible, center our clients' agency and empower them, and make sure that they're in the driving seat of their case. But we also need to be in a position to properly evidence their case, and to provide the country background evidence that corroborates what they're saying about their country and the risks they face, and in some cases to build and articulate their case where they're not able to. And COI research is absolutely critical in that. I always found that so many times COI makes the difference between winning and losing a case, and the fact that the lawyer has bothered to do some research and look up some useful COI sources that debunk what the Home Office is saying can make the difference between winning and losing a case. And lawyers wouldn't be able to do that without COI researchers. So they are complementary roles, and we both have a key role to play in empowering disabled clients. And in my current role, I left the bar a few years ago, and I now work in a support role in chambers. And research is a very large part of what I do. Legal research and various other forms of research. And I would say that research is central to the enterprise of asylum law, and you always want your lawyer to be the most informed person in the room. You want them to be more. They almost always will be more informed than the Home Office, but you certainly want them to be. And that's
why I'm going to have David as my lawyer.
Right. I think the last element of the question that was asked is looking at your sources of information. So I think this is a question for Maya and Joe about the project. Looking at your sources of information, did you include refugees and asylum seekers themselves, disabled refugees and asylum seekers themselves? I think is what's being asked there.
I will jump in. Our methodology for these reports doesn't usually include interviewing asylum seekers or refugees directly, and for many reasons, but ethical reasons primarily. And what we would normally do is and the reason why you've seen government sources within our bibliography is the first stage is we do desk research, which means gathering up all of the relevant information we can find on any source that has published information relating to our terms of reference. We gather this information and we go through it and identify where the key gaps of information are or biases, and then we would write a list of questions which try and kind of unpick thorny issues or fill gaps, and then we would identify individuals with relevant kind of specialism, knowledge, experience on the topic. And this would normally be kind of expert, kind of academic experts that you might find in tribunal systems, or regularly it will be organisations that are on the ground in the country of origin. In this instance, one of those persons with specialism happened to also be seeking asylum in the UK, but that was kind of irregular for our methodology. The people that we interviewed and which filled a big part of the report, I think much of the kind of information in the report which really generates new information has come from these interviews, and that those interviews were primarily with people with lived experience of disability, but who were still in Nigeria and working on the ground, primarily in disability activist organisations, and who, although they hadn't fled Nigeria and how they hadn't sought asylum elsewhere, they were both themselves experienced mistreatment, but also working with groups of persons with disability, and so kind of could speak authoritatively to those issues, and who I think, like you say, can define disability in their own terms.
I think one thing to add to that from our perspective as a lawyer, the difficulty we'd have if a COI report was based on accounts given by current asylum seekers in the UK is that the Home Office would say, well, these accounts haven't been tested in court. We don't know if this person's been found credible at their appeal. We don't know if this is true. They would use it to, and they of course shouldn't do that, but they would use it to try and discredit the report and we have actually seen that there is an example of that in the world of COI. The unsafe return reports on the DRC do rely in part on the experiences of people who were deported from the UK and their families. And the Home Office has consistently asserted that those reports are not reliable, in part because of that, because of the source of that information, and has said, well, we don't know if these people are credible, we don't know if they were found credible, and so on. So that is, while, politically, we obviously, and morally, we want to centre the voices of people who are seeking asylum. The difficulty with doing that in a COI report is we need information that a judge is going to find unquestionably credible. And that doesn't mean we shouldn't speak to people with lived experience, but usually it's people with lived experience who are still in the country, or at the very least who are not claiming asylum in the UK. And that's aside from the obvious research ethics concerns that there would be in airing someone's asylum account in a report when they were currently seeking asylum, which in general is not something that, I'm not a COI researcher, but certainly I wouldn't usually advise an asylum seeker to do that. It's not something I'd normally recommend, because there would be potential ethical issues for the researcher there. But I think from the perspective of how it's going to play out in court, you really want to make sure that the Home Office doesn't have any lines of attack against this document, and they can't say, well, this is just, you've just taken these random people's view at face value. You need to be able to show them that it's credible. Okay, I think it's probably time to wrap up. It's 6:30. Many thanks to everyone who's attended. We've had excellent attendance this evening, and many thanks to our great speakers. And many thanks to Maya and Joe for doing this project, which will be very helpful. And thank you to Amy at Garden Court for hosting and this webinar and organising the technology for us. So thank you all very much.
Thank you.